If you're planning on applying for your family member's green card petition, this could be for parents, siblings, brothers and sisters, spouses, and children. There's typical mistakes we see a lot when people are doing these cases on their own. So I wanted to give out this warning so you prepare for the top three mistakes plus a bonus at the end that you should really be prepared for to avoid problems. Because sometimes these processes, for example, for cases that go for brothers and sisters, could take 15 or 20 years. You don't want to go all the way down the line and then realize that you're stuck and you made a problem at the beginning of the case and now it's a problem and a bigger issue now. It might have been a waste of all that time. I'm immigration lawyer John Castrabi. We help families get together at our law firm and get back together in the United States through family-based and employment-based and all other types of immigration. If you want to schedule a private consultation, go to our website jqqlaw.com/contact. Fill in the box there and we can get into it. But let's start without further ado. Now, please note, none of the information here is intended as individual legal guidance. Please consult with an attorney that can talk with you privately. Okay, so the number one mistake that's troublesome we see people do in these cases is in the I-130 petition. Now, this whole program is going to be about the I-130 petition. This is what you submit to USCIS, the government, either online or by mailing it to them, saying this family member is a family member of mine. I'm a U.S. citizen or green card holder, depending on the type of case. And please allow them to have the opportunity to apply for a green card. It's not the green card application itself. Later on, or with that case, or later on, they'll need to do an adjustment of status I-45 in the United States if they're here properly, or through the embassy system and go through consular processing. But the I-130 petition is to let the government know that this relationship exists for a basis to be able to get a green card. And the number one problem we have, what we see is people list that they're going to do their case inside the United States, adjustment of status, instead of telling the government they're going to do it outside. So the spouse or the family member, brother or sister is outside the U.S., but they submit the case saying we're going to do it in the U.S., or they leave it blank, or they mark the wrong place, location. And what happens is once that I-130 petition is approved, the government keeps it in the United States because they mistakenly think that that's where you want it. The problem that comes up is for you to ask the government to move the case overseas for the brother, sister, parent, child, or whoever being overseas, you got to fill out a form called I-824, spend hundreds of dollars and potentially 1 or 2 years for them to fix the situation. And you'll find it be a disaster, especially if you're doing, a marriage case that should be done in a year or two, or bring your minor child over, or parents. It's a complete disaster when that happens. And unfortunately, we see it a lot because if you go online, you type in I-824, people will deal with situations. A lot of our videos come up because we talk about it a lot because we see the situation pop up a lot for people doing the case on their own. And so that's something I want to bring up first and foremost because when it happens, it's a complete disaster. What you want to do is, if you're not sure if they're going to be in the U.S. or outside, just designate the foreign embassy to go to. You can always switch it back to the U.S. easily. If you're going to switch it from the U.S. to overseas, it becomes a major disaster, and you want to avoid that. If you already submitted your case and it's pending, you could try calling USCIS, going to the online system, writing them letters, do everything you can to nudge them to change it from adjustment of status inside the United States to overseas, so that when the case is approved, you're not trying to fix it then, which again costs a lot of money, it takes a lot of time, a major headache you want to avoid. So that was the first thing that we want to mention because it's the biggest facet issue that becomes problematic. But the second one then is documentation regarding relationships. So marriage and birth certificates. A lot of times people don't have these. It's not proper. USCIS may even approve it, but later on when you go to an interview, they'll say, oh, these are not the proper documents. You're like, well, you already accepted them. Like, no, we made a mistake, and that does happen. So you want to make sure you have the proper documents at the beginning. With regard to birth certificates, the biggest problem we see is that the birth certificate is not registered in a timely fashion. For example, you're born, and then instead of a month, 2 or 3 months later, your parents taking you to the registration office, getting it registered with the government, they wait 1, 2, 3, or 4 years. The government comes back and says that took too long to get that registered, so we don't accept it. So that's a thing unfortunately we see all the time. But other things you wouldn't believe happen too. People's names are mistaken, their parents' names are mistaken, parents' names are missing, their date of birth is incorrect on the document. They don't have the stamps necessary on the document for it to be properly registered with the government, all these kind of stuff. So when we first get a case, we look this up, make sure it's okay, but and then submit it. But also marriage and divorce certificates. We've had cases where someone gets remarried before the divorce is finalized, or the divorce certificate, judge forgot to sign it, so the divorce is never final. And they get married, and then they have 2 spouses. So that becomes a problem to try to fix up. But sometimes the government doesn't notice that till the embassy. So they're 4 or 5 years into the process, and at the end, at the embassy, they look at it and say, oh, your divorce is never properly finalized, so this marriage is invalid, so we can't approve your case. You just wasted thousands of dollars, a bunch of time. Whereas if you had a knowledgeable attorney that could go and review these documents with you, we could try to hopefully avoid this kind of stuff. So that's number two, is the documentation requirements become very problematic. You want to be careful of that. They don't create bigger problems for you. And then the third issue is this: once you have submitted your case, if you move the petition or the I-130 petition, a person who signs that, you have to update the government of your address change. Now, this issue I'm about to speak about is gotten better now with the online system that they have that gets notifications, but it doesn't always get proper notifications. The problem is, once you start the case, sometimes the government asks for more evidence, and they'll send what's called the request for evidence, RFE. Now, they'll usually mail it to you, and you give you either 30 days, a lot of times 87 days to respond. If you miss that response period, they may be asking for more evidence, more clarification, or something like that, more documents, whatever it is. That's not the point here. The point is that you have to get that, have to respond to that. If you don't, the case is canceled. I've seen many people have cases that were clean, but there were just some typos, errors, or the government made a mistake asking for things they don't need. And then the person moves, they don't get that notice in the mail, and then they come to us and say, oh yeah, like, we got a denial notice. We went online, the case said denied, or I called USCIS, he said it's denied. And we look, and they say, well, you didn't respond in time to request for evidence. And the reason was because they never got the notice because they moved and they didn't update the government about their address change. Now, nowadays, they made it really easy, an online system a couple years back, and then they made it very difficult to get, which is you got to be able to log into your my.uscis.gov account and go to address change system there, and hopefully the government gets it. But that's the thing. If you have a lawyer gets these copies too, so it helps out get notifications. But especially if you have a brother or sister case that's 50, 20 years, you're definitely going to move in that timeline, and you have to keep updating your address to USCIS to get these notices that get sent to you so you can respond to them, because you don't want to wait 50, 20 years and realize your case was denied a long time ago. That's a disaster. Nieces and nephews will be kicked out of the case, not will be able to get green cards, and it's just a sad story. So these are the top three issues that we see. And the bonus is this: keep a copy of everything you send to the government. Please, please, please. People don't do that. Then they come to us and we don't know what was exactly said to them. The online system doesn't always show all the application and documentations you sent. And historically, we will do a Freedom of Information Act request, FOIA, FOIA request from the government to get a copy of it. It was taking like 6 months, a year. It got faster to a month or two. But ever since the Trump administration has come back, they were heavily redacting everything and not giving us the documentation we need. So we don't have all the information. And it's so important to be consistent in your paperwork. When you got a visa, when you got a green card, when you're filing for somebody, all the information has to be consistent. Inconsistencies, especially in the age of AI, will lead to red flags. So if someone did I-130 is approved and they come to us through the embassy portion, we want to make sure the stuff we're saying the embassy is consistent. If it's not, we have an explanation why, what errors they were. So it's very important. As this bonus point, please keep copies of your documents, because we don't want to say something later on that is not consistent, is different than what was said in the I-130 petition, and the government comes back and has problems with it. Who knows if it'll be fixable or not? Hopefully it will be, but it's an easy thing to avoid by having documentation. Just to scan a copy of it, keep it in your emails, keep it in your files, Google Drive, whatever you have, and so we could review that and be sure we're all on the same page. If you want to learn more about marriage-based immigration, which is similar to all the other family categories, most part, go to marriageimmigrationlaw.com, download our 50-page guide, marriageimmigrationlaw.com. And if you want to schedule a private consultation, you go to our website, jqklaw.com/contact. Fill in the info box there. We'll follow up with you about scheduling a private video time to talk with me. Please note, we don't go through WhatsApp, we don't text message, we just do video consultations so we can see each other to avoid any misunderstandings and fraud that happens when people say they're me but they're not. It was such a pleasure talking with you today. I hope we get a chance to talk with you, not about these issues. Hope we don't have these, but we can help with other aspects of your case. God bless, be safe. I'll see you soon.